Okay, it looks like we have a good number of members who have logged in. So welcome to the second meeting of the committee. And we, as always, will start with a roll call. So I'll turn to Gavin Young to take care of the roll call for this meeting.
Thank you, Carrie. As usual, I'll call two rolls. The first will be names of the committee members and alternates for committee members. After your name is called, would you please say here so we know that your microphone is working? So that's the first roll. Carrie Ricci.
Here.
Certainly here. Allison Ho.
Here.
Thank you. Alice Kottmeyer. Alice Kottmeyer. I believe I saw her. She's around somewhere. Anika Cooper.
Here.
Thank you. Anna Shavers.
Here.
Thank you. Hi Feldblum.
Here.
Thank you. Dan Cohen. Daniel Cohen. Albert Lynn. Albert Lynn. Eloise Pasikoff. Emily Bremer.
Here.
Thank you. Erica Lietzen. Erica Litzen.
Sorry, here.
Thank you. Helen Serasio.
Here.
Thank you. Jim Tozy.
Here.
Thank you. Kenny Wright.
Here.
Thank you. Michael Cole.
Here.
Thank you. Let's see. Judge Sokajewski on behalf of Patrick Nagel.
Here. Sakachevsky.
I apologize. I'll have to practice it a few more times. Randolph May.
Here.
Thank you. Robert Gerard.
Here.
Thank you. Roxanne Rothschild.
Here.
Thank you. And Russell Wheeler. Russell Wheeler. Great. We may have some later attendees. Is there anyone from the committee that I did not call? Great. The second roll will be the names of the ACUS members who are not on the committee or serving as alternates. Again, would you please say here after I call your name so we know your microphone is working? Bill Funk.
Here.
Thank you. Nancy Griswold. Fred Jacob. All right.
Here. Sorry about that.
Thank you. All right. That is all we have. I believe we now turn it over to Matt for opening remarks.
I don't think you called Jeff Lubbers.
I apologize. Jeff Lovers, I see you. Are you here?
Here, yes,
Thank
thank you.
I have no opening remarks other than to thank everybody and especially the representatives of the American Bar Association for joining us and sharing their expertise on the matter. And also I see Jim Sandman, the former president of the Legal Services Corp. Gavin, I just have just a question on the membership. You referred to, maybe I missed you, Bill Funk as an alternate. Is that correct or incorrect? That doesn't sound right.
He's listed. I believe that Bill Funk is not on the committee proper.
Okay, but he is an
ACUS member.
ACUS member. Okay.
Yes.
And one other question is Andrew Emery Andrew Emery joining us?
I don't think he's going to be able to make it today.
Okay. And is there anyone else from well, I don't want to say you're necessarily from the ABA, Bill, because you're representing the section. Is there anyone else from the ABA on the line?
I believe we have,
Well, yeah.
Go ahead.
I am. This is Anna Shavers. I'm not here as representing the ABA, but yeah, I'm from the ABA.
But this is what I just wanted to clarify in Andrew's case. Anna and Andrew should be speaking in their capacity solely as ACUS members and not on behalf of the ABA. Those roles would be incompatible. I think Bill has the flexibility to speak on behalf of at least the section. But so I just wanted to clarify that at the outset who was speaking on whose behalf. I have nothing further, Carrie. Thank you.
Matt, I would add that Ellen Rosen and Mary McDermott are on the call as well.
No, I know that, and they're obviously speaking on behalf of the ABA and not as ACUS members. Thank you.
Okay, thank you for that. And I'm Carrie Ritchie. I'll be co-chairing this meeting, and I'm going to go over the ground rules. And I'll apologize in advance. I'm going to read directly so that I don't miss any of the rules. Please note that only ACUS members, whether or not on the committee, and their designated alternates have full speaking privileges. ACUS members include government members, public members, senior fellows, liaison representatives, and special counsels. Again, only ACUS members have full speaking privileges. However, with respect to attendees other than ACUS members and alternates, participation requires unanimous consent of the committee members. Time permitting, I'll consider calling on such attendees at appropriate points, and we will presume that committee members consent unless they raise an objection. So if there are any concerns, you can raise your hand and let me know. Otherwise, we'll presume consent. And I apologize, I had a plumber show up in the middle of our meeting, so I'm a little bit out of breath. If any such participant would like to speak, please so indicate in the chat feature. And if you don't mind, maybe indicate whether you're representing any organization. And you can use the Zoom's hand raise feature or indicate in the chat and wait to speak until I call on you. You can then unmute yourself, and please remute yourself when you're done speaking. Only members of the ad hoc committee, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels have a vote. Please do not vote unless you're a member of the committee. Staff counsel Gavin and I have a list of the committee members in case you're unsure. To avoid background noise and feedback, please keep your microphone on mute and either use Zoom hand raise feature or add a comment in the chat feature if you'd like to speak. I'll then call on you and you can unmute yourself. Please remute yourself when you're done. For all participants, please use the chat function only to indicate that you'd like to speak, or for committee members and alternates if a vote is called. Please do not hold any sidebar discussions or put substantive comments in the chat feature. So I just want to highlight that again, because in other meetings you might be used to holding comments, making comments in the chat. It becomes too difficult with the size of our meeting. So please use the chat function only if you want to speak. I'd also ask that ACUS members and their designated alternates use the webcam to kind of better mimic a meeting environment if you can. So those are the ground rules. Are there any questions? With there being no questions, I will turn to Reeve Bull, who's going to talk a little bit about the new framing of the recommendation document that will help speed our meeting along, hopefully focus us for this second meeting. So Reeve.
Wonderful. Thank you, Carrie. And thanks to everyone for joining. So I'll be very brief. I just wanted to offer a few sort of framing remarks at the outset as to sort of why the recommendation document that you have in front of you is structured the way that it is. Each one of these is a little different. And, I want to just sort of go over briefly sort of what this document looks like and sort of what we'll be doing hopefully over the course of this meeting. So, obviously we had a very good discussion last time and, went over some very, significant topics. Things like, for instance, what sorts of topics should any rules that agencies adopt cover? How should agencies enforce any rules that they do adopt? And how can ACUS, or ACUS's Office of the Chairman, be most helpful to agencies as they go about adopting rules, if they do adopt rules? Since that meeting, we've done some additional research. One thing that you see that Gavin circulated to the committee is a memo by our Principal Deputy Research Director, Jeremy Grayboyce, looking at the question of agencies' authority to adopt rules, covering both lawyers as well as non-lawyers. In addition to that, the ACUS staff, Matt, Jeremy, Gavin, and I, as well as the committee chairs, Professor George Cohen, met briefly with members or with Ellen Rosen and with Mary McDermott from the ABA, who offered a very helpful set of clarifying comments to sort of follow up on the discussion we had last time that I'll mention briefly as I sort of get into the different topics for today's meeting. So, as you'll see, in light of this additional research and in light of the, discussion we had last time, the way we've structured this document is, you'll see that it has all of the recommendations, all of the recommendation text that we had last time. It doesn't have a preamble yet. That'll be for next time. And we've accepted the edits that the committee decided upon at the previous meeting. But as we saw last meeting, there were sort of some foundational questions, some sort of fundamental questions as to sort of what the scope of this recommendation should be, what sorts of topics it should cover. So you'll see in the document there are a handful of marginal comments that highlight those foundational questions, as we call them. And I think one major goal of this meeting will be to try to drill down on each of those, maybe even before we get to recommendation text, and try to decide how we want to address each of them. And then I think based on that, the recommendation text should hopefully sort of write itself. We'll sort of be, modifying it and tweaking it in this meeting. But I think once we get answers to these foundational questions, hopefully the rest of the document should flow pretty nicely. And the same thing with respect to the preamble. We'll have a draft preamble for you next time. It will take into account what we decide upon at this meeting, and we'll sort of structure it accordingly based on the topics that we cover. So let me just sort of briefly mention sort of what we see, or elaborate a little bit, compared to the document that you have in front of you on sort of what those key questions are. So first, and again, this is entirely up to the committee, but as sort of we went back through on the ACUS staff and considered, how best to structure the document, our reaction was, at least with respect to what we called qualification rules last time, sort of what policies, rules agencies want to put in place in terms of lawyers' qualification or non-lawyers' qualification. It didn't really seem like there's a whole lot we can say as to that. So for lawyers, as you know, the Agency Practice Act, 5 U.S.C. Section 500, limits agencies' abilities to impose supplemental requirements on lawyers absent some separate statutory authorization. That's probably something worth noting in the preamble. But as a consequence of that, it doesn't really seem that there's a whole lot we can say as to lawyer qualifications just beyond that statute. And then with respect to non-lawyers, it seems from George's excellent report that there's really so much variation from agency to agency as to which agencies allow non-lawyers, and sort of what the qualifications are, such that to try to offer best practices recommendations for non-lawyers may not really be feasible. So again, it's up to the committee, but you'll see in the draft text that we circulated, we removed that section on qualification in a red line. And so that's why it's structured the way that it is. A second key point to consider is how prescriptive the committee wants to be when it comes to the content of rules. So, the way that it's currently structured, it's basically a menu of options. We're not saying agencies adopt rules on X, Y, and Z topics. It's more, as agencies are considering whether they should have rules, here are some key topics that you might want to consider. And that's drawn from George's excellent research into, the most common types of things for agencies to address. One embedded question within that is, if we do go with this menu of options approach, do we want to limit the topics to things that relate to the specific proceeding? Or do we want to expand it a little bit and include content or actions that a party might undertake that might bear upon the representative's qualifications or sort of ability to practice before the agency that goes beyond the conduct in a particular proceeding? The main thing we were discussing last time was a criminal act. If somebody commits a criminal act, that doesn't really relate to the proceeding itself, but it may bear upon the person's integrity. So that's one thing to consider. Do we want to go beyond that, or do we just want to limit it to content in a particular proceeding? A third thing to consider is what, if anything, the committee wants to say as to harmonization. We have something in there on incorporation that agencies should at least consider incorporating from state bar rules or other types of rules. And then the agency should be careful when doing so to make sure that those rules do in fact apply to their proceedings. And the question is, do we want to go any further than that? Do we want to encourage incorporation? Or there's a separate recommendation where we suggest agencies might want to try harmonizing rules, either within the agency or perhaps even among different agencies. It seems like that's an open question and something the committee will want to discuss. What, if anything, do we want to say about trying to achieve greater harmonization among rules? A fourth major question is enforcement. What should agencies do to enforce the rules that they have in place? And this where I'll briefly mention the discussion we had with the ABA representatives who very helpfully laid out last time. And I think the terms they used were sanctioning as opposed to discipline. And I may well get this wrong, but what I understand the difference between the two to be is that sanctioning refers more to basically an action that the agency may take in light of conduct in the particular proceeding. So if somebody is disruptive and is disqualified from serving as a representative in that particular proceeding, that would be more in the same nature of sanctioning, whereas discipline would be more actions that take place, or rather penalties or other disciplinary actions the agency may take that might go beyond the particular proceeding, in the nature of a monetary sanction or perhaps disqualifying somebody from serving in subsequent or appearing in subsequent proceedings. So I lay that out simply, for the committee to consider when it gets to that recommendation. But hopefully that sort of helpfully clarifies the discussion we were having last time as to sort of different ranges or different types of enforcement actions agencies may take. And then one final thing that I will mention is basically how ACUS can be most helpful to agencies as they consider adopting rules. So you'll see we've added a recommendation at the very end of the document, which is essentially a recommendation from the committee to the Office of the Chairman of ACUS. And it's that the Office of the Chairman would initiate a process for adopting a set of model rules that agencies should consider, and relying upon a number of different sources and consulting with different entities like the ABA and so forth. So let me stop there. Those are sort of the what we see as sort of some of the key issues that the committee will likely want to focus on. There will probably be others as well. But we've sort of highlighted those with the goal of sort of drilling down on each of those points in the course of this meeting. And I think once we get an answer to each of those, then hopefully the recommendation text and the preamble should be pretty easy to put together. So let me stop there and turn it back over to Carrie.
Thank you, Reeve. That sounds good then. So we can open the meeting for discussion. And as we're doing that, if there's anyone who has any general overall comment after having read what we were presenting today, feel free to do that as we're pulling up the recommendations. But if no one has an overall opening comment that they wanted to make, we can go straight to the recommendation. All right, looking at recommendation number 1, adoptions of rules. Are there any comments on 1? Okay, we can move on to 2, rules of conduct. Are there any comments, questions, or concerns on 2? I'll give you a moment to read number 2. And I don't see any. Oh, Erica.
Yeah, I just had a quick question. When we say agencies, it's the second sentence. When we say agencies should ensure that all adopted or incorporated rules are applicable to the adjudicative proceedings they conduct. What do we mean there? I mean, is this not a decision to make them applicable? Are we trying to get at something else, like are appropriate for, are suitable for, or what are we trying to do there?
I can jump in briefly, Erica, in terms of at least sort of what we were thinking when we were drafting it. And I think it's basically what you're suggesting is appropriate for. I think what we're trying to get at is that, you know, agencies should not just incorporate wholesale. They should consider, you know, rule by rule, does this actually apply to the proceeding, you know, our proceeding, or is it inapplicable? So, you know, go through, tailor them, ensure that they're directly on point. So I think appropriate for, as you suggest, may be a better term to achieve that. So again, I can't speak for the committee, but it seems like a good change to me.
Does anyone want a motion? Do we want to go with appropriate? Was it appropriate for?
I think that's a little clearer personally, but
I agree.
I agree.
Okay. Any other comments on 2?
We have a raised hand from Jeff Lubbers and Eloise Pasikoff. And Carrie, I'll mention that when I'm sharing my screen, it's difficult for me to see the raised hand. So I would defer to you about the best way to call on people who have raised hands.
Okay. If you can see them, that's fine. Go ahead and call. I do see Jeff and Eloise. So if we could start with Jeff.
Thank you. I just wanted to have us consider the last sentence a little bit more, because it says that agencies should scrutinize incorporated rules. That's really the recommendation, and modify them accordingly. I think this is a little awkward. I think it should be something like agencies should consider whether any incorporated rules applicable to attorneys should be applicable to non-attorneys, and whether they should be modified before doing so, or something like that. Because right now the recommendation just says they should scrutinize and then modify them. But I think maybe there might be a need for 2 separate rules in some situations.
Okay.
So I just throw that out there for the experts to chew on.
Thank you. And Eloise?
That seems reasonable to me. So I'll just be a voice. I'm not an expert, but I would voice support for Jeff's suggestion. I didn't hear that we had weighed in on whether to move the making the rules available to the transparency section, and I was just going to be a vote for yes, moving to the transparency section, because I think it muddies here. The disclosure muddies the substance.
The sentence, agencies should ensure that all adopted or incorporated rules are available at no cost to the public. And you're
right. I was just
that perhaps should move to the transparency section.
Right. So in response to the comment from the office of the chairman on the document, I was going to be a voice in support of yes, moving.
Okay, and I see we have a hand raised from Emily Breber.
Yeah, sorry, first I applauded.
Okay.
So I guess one question I have is, do we want agencies to consider the availability of the rules as part of, because in our incorporation by reference recommendation, we sort of recognize that there are some rules that are incorporated by reference that may not be available. And so I guess if we want, I mean, I agree that the incorporation, if it's really just about transparency, should be put later. But if part of what we're trying to indicate to agencies is that they should consider whether potentially copyrighted rules are available to the public, and they should consider that at the time they're deciding whether to incorporate or use them, then it might be appropriate to retain that, albeit in a more clear formulation in this part of the recommendation.
Okay, thank you. And Russell Wheeler also has a hand up.
It's just a small point. Does are available
mean the agency should make them available, or they just have to be sure that somebody somewhere is making them available? It's just a question. To put a burden on the agency to make them available itself, which implies, I guess, on its website or whether or not. So, for example, incorporated rules, maybe they're available on the other site from which they're incorporated. Is that good enough? Or should the agency say for sure we've incorporated these rules and actively say these are the ones that apply to this agency? I'm just not sure what "are available" means.
Good point. Reeve, do you have a sense of what we're trying to say by "are available"?
I mean, I think what we were sort of getting at, although I think Russell and Emily raised good points, is that they were available on the agency website. As to they're being available elsewhere, I mean, I guess that would be sort of less optimal from a transparency perspective if they're not also available on the agency's website. But as to the incorporation question, I guess maybe I would have a question myself as to sort of whether there are any instances where rules are not otherwise publicly available. I mean, it seems like if it's a state bar authority, at least, that's adopted the rules, then presumably they would be public. So I guess there's sort of a threshold question: to what extent do we want to get into whether or not the rules are already public? And then I guess there's sort of the separate question of, regardless of whether they're public or not, to what extent should the agency then feature those rules on its website? And I think what we were trying to get at here is the agency should in fact do that, because that would ensure, public access, easiest possible public access. But that's something we should probably clarify.
Reeve, are there any of these, are any of these rules copyrighted in any way? I mean, the ABA rules, I think, model rules are available to the public. The ABA could clarify. I've never heard of a state set of rules of professional conduct that aren't available to the public.
Yeah, I haven't either.
I can speak to that. In my casebook on administrative law, and we wanted to include some model rules of professional conduct from the ABA. We were told by the ABA they were copyrighted. We couldn't do it without paying a fee to the ABA. So instead, we just copied them from Kentucky's rules, which are the model rules that Kentucky adopted, and they're free to the public. So my understanding is the ABA rules are copyrighted, but you can get them public form by just copying them from some state that's adopted them.
We have the alternate from SSA.
Hi. Oh, that's an easy way not to have to massacre my name. So what we really want to say are readily accessible. Doesn't necessarily have to be on the agency's website. We don't really care as long as someone can find it without having to go through hoops to do it. So maybe instead of available, we should say accessible. And if we want to make it even more clear, we can say readily accessible.
Gavin, I think Mary wants, I suspect Mary wants to speak directly to the Bill Funk's comment.
Please.
Hi, yep. So the ABA model rules are both copyrighted if someone wants to use them, but they are available to the public, as are the rules of professional conduct for all the states that license lawyers. So both are readily available on the internet.
And I see Emily has a hand up.
Yeah, I would just suggest that we not use the language incorporate by reference, because as ACUS knows well, that has a term of art in FOIA and in regulations. And I just don't, I think that is like a lot of baggage we don't need or want here, because what we really mean is that agencies are either adopting or referencing existing rules, which doesn't require the, so I would just say, is adopting or relying or referencing or something, and leave the phrase incorporation by reference out of it, because I think you're going to raise a lot of questions for people that are maybe not necessary to raise.
And Emily, you would also have to, the agency would have to clear the OFR process, wouldn't it, by
Yeah, I don't know that we need to go there, so.
I will just toss in as well that I don't know, when we're talking about accessibility for an agency, they usually want to make sure that they have posted themselves the information, because you can't control what's posted at another website. And if the rules later change, and you're referring to rules that are no longer what you thought they were when you first adopted them, that could be problematic as well. So I'll go to, I believe, Kai Feldblum has been waiting.
Actually, I haven't been waiting. I just want to wrap back. This is just in the idea of moving forward in terms of stuff. So to go to a few things. One, in terms of lines 10 and 11, I do think, per Eloise's first comment, we should move that to transparency. I think we've had that good conversation about whether there's copyright or other issues. Let's look at that again when we get to transparency. And then I think we can also look at whether it should be accessible, available, whatever. We have other things said. So I would take that for lines 10 to 11. I agree with the piece of not saying incorporate by reference rules. And it was a little odd to then say, or instead draft their own rules. So I think you can say on line 9, agencies should consider whether to adopt or reference rules promulgated by other authorities, period, right? That's your first thing. You can decide whether to adopt or refer to rules. Adopt or refer should be up in line 9. Okay, take out reference, rules promulgated by other authorities. Okay, period. Because I don't think, unless someone else can tell me, I don't think you then need or instead draft their own rules, since we have adopt ahead. So I think you can do that, take that out. If you take out the first part of the sentence, then that goes to the transparency. You have to start again on line 11. Don't take out agencies should ensure that, okay, just take out from all adopted or incorporated rules are available at no cost. Okay, just, yep, take all that out with the note that we're going to get this point in the transparency section. And then you have agencies should ensure that the rules, whether they're adopting them or referring them, that the rules are appropriate for the adjudicative proceedings they conduct, and consider whether any modifications should be included. Now, just looking at that right now, I'm not sure whether modifications to adopt it, we would now have to deal with that on line 13. So let me just be quiet to see what people think about the other editing suggestions, but I will note that if we are considering adopting to mean things they write themselves, you're not going to have modifications to adopted rules. And if we're going to take out the word incorporated, anyway, I'm not even sure we need line 13, but let me stop there in terms of the other suggestions I've made.
Okay. Anna Shavers.
I was going originally when I raised my hand, I was going to voice support for Emily's concern about using the incorporate by reference, and I was quickly trying to draft some suggested language, and I like Chai's language that she's given. So I guess right now I'm just supporting what the last two speakers have said about getting rid of that incorporate by reference.
Okay.
I don't have a suggestion for Chai's last question yet about the modifications, but the language she suggested so far I support.
George Cohen. Thank you, Anna.
Yeah, I just want to make a point about the part that's being moved, the transparency part. So maybe it's better to discuss this later, but I'll just raise it now. It's useful, I think, to note that a lot of agencies, are the ones that I looked at that have these what we're calling incorporation rules. It would be kind of hard to list them or even link them, because some of them say the rules that apply are the rules of the bar in which the lawyer is licensed, if it's a lawyer practice, or they may say the rules generally applicable in federal courts. So unless you're going to have links to every jurisdiction, which I guess you could, it would be pretty cumbersome to do that. I mean, I think that's a problem with the way the agencies are currently doing incorporation, but I'm just raising that as an issue for discussion for later.
Thank you. Randy May.
All right, thank you. Hello, everyone. When I put my hand up, I was just going to say I agreed with the gist of Kai's suggestions. And I guess, I mean, just to put a pin on it, you would take out the word incorporated is correct in line 14. You could say any rules adopted or referenced, but you could just take out incorporated, probably would be cleaner.
Thank you. Bill Funk.
Yeah, I'm wondering why we took out, I mean, I heard what Charlie said about taking out instead draft your own rules. I thought that was important to say that, you know, you have two options. You can either adopt somebody else's rules or you can adopt your own rules. And then the next sentence would go that with respect to adopted rules, to determine whether they're appropriate for the adjudicatory proceedings they conduct. It just seemed to me that we don't want to say to them, you should consider adopting other people's rules or do nothing. We're saying you should consider adopting rules of others or adopt your own. So I thought keeping or instead draft their own rules was an important point. That's all.
Yes, and if I can just go in with that, you're exactly right. Please undo that. I was, because it felt like adopting their own rules or referring, but thank you very much. It's whether to adopt or refer to rules promulgated by others, or instead draft their own rules. And then that helps with line 13, whether any modifications to, so then the adopted is fine. Now we don't have the word incorporated. Appropriate that and consider whether any modifications to I don't know.
To adopted rules, just take out or
rules, exactly. Consider
take
whether,
out or incorporated in line 13.
Yeah, you don't need to any adopted rules, right? Because if they're drafting their own rules, they've already done it, which was what was disconcerting there. Sweet.
Thank you. Nancy Griswold.
Yes, ma'am. So I am the Deputy Director for the Office of Workers' Compensation Programs, which is a lower level adjudicator. We have ALJs at the Department of Labor, but this is the level that adjudicates, you know, right below them. And I just wanted, as a point of clarity, to know whether the rules or whether this recommendation is intended to apply to that level as well, because we do have representatives, attorney and non-attorney representatives, and problems that are very similar to what I've heard on the previous call.
And Gavin, do you want to take that?
I would defer to Reeve on this point.
Okay.
So Judge Griswold, to make sure I fully understood the question, you're asking whether the recommendation would include both non-lawyers as well as lawyers. Is that
down to the level where you adjudicate? Sorry.
Yeah, I think I saw that at the very beginning, that it applied to both attorney and non-attorneys. But my question, I think, is about the level that it would apply to, because I think we generally think of these sorts of rules as taking place in ALJ level sorts of adjudications. But it would be really helpful if they were also applicable at the lower levels, because we do have very similar problems at lower level adjudications. Quite frankly, to the point of some representatives coming in and asking for personnel actions to be taken in order to, you know, to be taken against federal employees. And so the question of influencing the integrity of an adjudication, I think, is very relevant there. And I was, by the way, very interested in Professor Cohen's report. I thought it was excellent. So well done.
So yeah, it's a great question. I guess I could sort of weigh in on sort of, that sounds right to me. It sounds like it would sort of, cover the full range of proceedings. And I guess that's probably something we would clarify in the preamble as to sort of, the range of proceedings covered.
Yep.
I don't know if Professor Cohen, if you have any thoughts on sort of your research as to that point, but that sounds right to me that we would want it to sort of apply more expansively. But let me ask you if you have any thoughts on that.
That sounds right to me too, but I did not make that distinction in my report, and I am not that familiar with the proceedings below ALJ level. But off the top of my head, I think absolutely they should apply in any kind of proceeding.
Any kind of adjudicative proceeding. Is that correct?
Correct. Yeah.
I think that would be wonderful. And from our perspective, if that could be clarified somehow in the preamble, we would appreciate that. So.
Right.
Thank you.
Thanks much.
I see Randy May has his hand up.
Oh, no, not the real hand, not the yellow hand. I was just scratching my head there.
Okay.
Carrie, can I just, while we're on paragraph 2, I don't know if we're done here. This refers to a promulgated by an authority. Is the ABA considered an authority here? In other words, should it say authorities on professional associations or something like that?
For what it's worth, yeah, I think that that would be my inclination. I think by authority, we intended to sort of encompass it, but you're right. I think to clarify, to say something more professional organizations would be better, because I think we certainly do intend to include those. So Gavin, do you want to add that, or professional organizations?
Good catch. I don't see any other hand raised for line 2 or paragraph 2. Can look at paragraph 3.
We have hands raised by Bill Funk and Jeff Lubbers.
Okay. Bill Funk?
I was going to mention we still have incorporated in line 18 of paragraph 2. And you can just take out that and just say rules. That will work there. And then we'll have incorporated again in paragraph 3.
That needs to come out. And Jeff Lubbers.
I was going to say that I thought the sentence would stop at the end of doing so, and everything else would not be necessary.
Anyone have any concerns with that? Thank you, Jeff. Okay, I think now we can move on to paragraph 3.
To the point that was raised about this bracketed language, given that incorporated was struck in paragraph 2, I'm assuming there's support for deleting that as well, the entire bracket.
Erica, I see your hands raised. I don't know if you wanted to speak to that point, if you had something else. Are there any concerns with the bracketed language and removing that? Okay, and I think we can go on to Erica.
So I have a suggestion about paragraph 3, and it really just goes to the list. And I want to raise another issue, which is I am worried about use of the complaint process to harass attorneys and others who might be representing or putting forward sort of unpopular causes or making arguments that are threatening to sort of more powerful, presumably regulated interests. I'm concerned about the diversion of agency resources. For example, if there's serial complaints and I'm worried about reputational consequences for the representatives, assuming there's transparency, which we seem to be sort of nudging people towards, even if the representatives are vindicated. And I'm also concerned about the possibility of reputational consequences if they're not vindicated, because the complaining party found an ally at the agency. And I think there's some risk that opposing parties would use the complaint process to delay ongoing proceedings. And I think the solution, from my perspective, is to add some language about abuse of the complaint process into paragraph 3. And I was thinking that one of, in this list of A through whatever it is, we might consider something along the lines of, so right now it says agencies may want to wish to consider, and it would be something like the process for identifying and dismissing complaints that are, no, in the list. I'm sorry, in the list.
So you would add to the list?
Yes, it would be in the list. And actually, I take it back. I think it might go better in paragraph 7. Let me wait and suggest it for 7.
Okay.
I'm sorry. Because 7 talks about the disciplinary process, and I think it belongs in the disciplinary process. So I'm sorry. I'll wait until we get to 7.
All right. Are there any other, anyone else want to speak to paragraph 3? Jeff Lubbers?
On line 23, I don't really like regulatory interest. Thoughts about regulation. I think we can say something like that, but that may still impact a legitimate agency interest.
Just take away regulatory.
That may still impact her.
Why not just delete regulatory, the word?
Yeah.
Regulatory.
Well, it's not creating an interest, it's impacting an interest or affecting an interest. Yeah.
But may still impact a legitimate agency interest.
You want to use affect rather than impact, that's okay too.
That may still affect a legitimate agency interest.
Yes, thanks.
And Erica, looks like you have your hand raised again, or is it still up?
I can't figure out how to unraise it right now because I got rid of my self view. I'll figure it out.
Okay. And Bill, did you have another comment?
Yes, I'm with Jeff on the problem here, but I'm not sure I like agency interest. I think it should be something more like shall affect, may still affect an agency's, the integrity of agency adjudications. I mean, the point is that if we get something like somebody's, has committed a felony somewhere or engaged in violence against other parties in some other situation, we're worried that they'll do it in an adjudication here. It's not just an interest of the agency generally, is it?
That's fine with me.
So then eliminate a legitimate agency interest.
Any other comments to that point or to anything on paragraph 3?
I have something on one of the list items if we're at that point yet.
This is Randy May. I'm just not sure that integrity is the right word. It may be too limiting. I mean, to me, that implies something that's different than some of the things that are in that list. If we keep the list, I mean, it seems to me that maybe just conduct that may affect the conduct is the word we've been using. I mean, I don't know whether integrity is too limiting, but maybe I'm the only one that sees it that way.
Would it work to just say may still affect agency adjudications and not be that specific?
Or
Is
I'm fine with the conduct of agency adjudications.
I think you want to put in adversely. I mean, everything people do could have an effect. The issue is,
Mhm. Good point, yeah.
I can live with adversely affect the conduct.
Yeah, that makes sense to me.
And Russell, you have,
Well, just a small point, but we're talking two different kinds of conduct now within the same sentence. Performance or it seems to me, it's just a little, it's unaesthetic, if anything else, to be talking about attorney conduct. Now all of a sudden it's the conduct of agency adjudication. May affect agency adjudication. I don't know, why do you need conduct? May affect agency adjudication.
or you can get rid of the first conduct or say actions.
That's fine too. And that's better, as a matter of fact. Include actions likely to occur.
so up on line 21,
Yeah,
change conduct to actions.
just anything to get those two, so those two words don't bump into each other, that's all.
Mhm. Any other comments on paragraph 3 before we go to the list? I see some hands raised. Kai, did you have a comment on paragraph 3?
I had just a tiny conforming one. I like that about actions instead of conduct on 21. And then I think you just need to make the same change on 22, because it's actions that occur during the particular adjudication and actions exactly that may occur outside. And then both of those may still adversely affect agency adjudications.
And Bill, your hand is up. I don't know if it was still up or if you had wanted to comment on that.
I have something on paragraph F under 3, if we're onto the list.
Okay. Alice, did you have a comment on paragraph 3 before we go to the list?
Yeah, I thought that we wanted to keep conduct on what is now 23. In other words, may still adversely affect the conduct of agency adjudications now that we took the other conducts out.
Right.
Because I think that sounds better.
Yes.
Instead of just adversely affect agency adjudications. I don't know why it sounds better, but maybe it's a style thing. That's all I had.
And now, Bill, you had a comment on F?
Yes, I simply didn't understand what including conduct not limited to that occurring during a jurisdiction. I don't know what during a jurisdiction means.
I think that's probably a mistake.
Yeah.
An adjudication would be what I guess.
Yeah, I think that's supposed to be adjudication. And Alice, I see your hand is raised. Is that still, did you have a new comment?
This is a new one.
Okay.
I was asking about A. Conduct intended to disrupt an adjudication. How do we know what their intent is? Why not just conduct that disrupts, or am I changing it too much? It would be conduct that disrupts an adjudication. Or does that change the intent of what you're trying to do?
I mean, for what it's worth, I would think that improves it, Alice. I don't know. Russell, I think you might have had some suggestion on this language. Does that accord with your thinking as well?
Yes, fine. What I did with all of these is I went back to the notes in Professor Cohen's paper to try to pick up the rule that he should correct me here if I'm wrong about this, pick up the essence of the rule or the behavior people were getting at and make it a little more specific. But I think the point is well taken. Conduct that disrupts an adjudication is better than intended to disrupt.
Okay, thanks.
But I'm saying, I'm not entirely sure how that intended got in there, but I think it's fine to take it out.
It's in the ABA rule. That's why you put it in there.
Okay, so I was just drawing from that, as I
Yeah.
said before.
Nancy Griswold?
Yeah, just sort of the other side of that. So I think there is conduct that may not affect the adjudication simply because the adjudicator has integrity and moves forward in spite of that conduct in an ethical way. But the conduct itself is actually designed to influence the adjudication. And I would go back to that reference that I made before of, threatening some personnel actions against adjudicators and that sort of thing. You don't see it in the ALJ realm, but you do see a lot of it at the lower levels. And it's sort of an unlevel playing field when you get letters written to multiple congressmen requesting that certain folks be terminated because an adjudication is not going the way that a representative might want. So that is an intent question. And so for me, that's sort of the other side of perhaps leaving that in.
Did you say seeking to disrupt an adjudication?
Or designed to disrupt? Or designed to influence, or, anything like that, I think would be helpful. Otherwise, I think you end up with, if it wasn't a successful attempt, then you have no way of acting on it.
Can I just intervene? K is on that point, and I feel like maybe they should be cut and pasted next to each other, or at least we can scroll to see them together. That's what my hand is up for. So I just didn't want us to get too far. I'm taking my hand.
Yeah, I don't think influence would belong in A. I see, Bill, you have your hand up? Is it on this same point?
Yeah, well, yes. I mean, you want something that you want to get conduct that does disrupt, even if it was not designed to disrupt. And as a general matter, I don't see anything here about failure to follow the judge's orders, or not complying with the judge's orders. Counsel, sit down. No, I won't sit down. Now, is that disruptive, or it may not disrupt very much, but we have knowingly disobeying rules, but
that could be amended, couldn't it?
Amend E to include
valid agency rules or adjudicator's order, something like that.
Well, good, I like that. But then I'm still in A. I'm just, what about actions that disrupt, even if they weren't designed to disrupt? And how do you prove designed as opposed to the actuality?
I think the point was that a skillful adjudicator will keep the disruption under control. But I think that was the point made before. It may not have the effect, but you're still trying to do it. So it creates an extra headache for the adjudicator.
Why not just say that disrupts or is designed to disrupt?
Sounds good.
How is design different from intended?
That's where we started, was getting rid of intended to start with.
I don't care between intended or designed, but I think keeping disrupts in there is.
I'll just mention that paragraph 3 does indicate that it's a negative, I can't remember the exact language and I can't see it right now, adversely affect the conduct of agency adjudication. So that the paragraph 3 would seem to me to indicate that the following list are about adverse effects, whether intended or not.
That's only applying to things that are outside the agency, outside the adjudication.
Okay. So that applies to all of these. Is that particular that means? Okay. I'm sorry, Bill, did you still have a comment?
Well, I have more on the list, but not on this particular point here.
Okay. Does anyone else have a comment on this point, or?
I would vote for intended rather than design.
Does anyone want to speak to the intended? I know that was raised, that was problematic. But now that we've gone full circle.
Did George say that intended is what appears in the ABA rules, or did I miss that?
That's correct.
Right.
Intended is what appears in the ABA rule.
If it's good enough for the ABA, why is it not good enough for ACUS?
Well, I don't know about that, but
Yeah, I agree in this case, but not, let's not make that a universal rule for ACUS.
Okay.
But it's okay here.
Yeah, I mean, I was just thinking this kind of, I mean, intent is not exactly an unknown standard to the law.
And Bill, you had a comment on another portion?
Yeah, I'm at this point, I'm down to J, which isn't on the screen.
Not
yet.
on the screen. Yeah, we could go down to J.
And it's sort of a question. It has the knowingly making false statements or failing to correct such statements, failing to correct knowingly false statements. About failing to, how about knowingly, how about failing to correct false statements, period, whether they were knowingly made or not. I mean, maybe it has to be knowing failure to correct, but I mean, if you make a false statement by mistake, and then you find that you made that mistake and you don't correct it, that would be wrong. So that's why I say knowingly failure, knowingly make false statements, or knowingly fail to correct false statements. Knowingly fail.
So as it appears on the screen would be your recommendation.
Well, except it should be knowingly making false statements for the tribunal, or knowingly fail to correct.
Fail to correct.
Does it have to be to the tribunals? This is the only time we mention the word tribunal in the whole recommendation.
That's probably my fault for borrowing it from the rule in Professor Cohen's. Should have been the agency.
During the proceeding?
Yeah.
Gavin, on line 42, where it says failing, it just should be fail. Line 42, fail. Just fail.
It's
Then-
parallel to making.
Then making would be make.
No, it's knowingly, well, knowingly make false statements, or knowingly fail.
Erica, you wanted to jump in on that? I see you shaking your head.
Oh, I'm only shaking my head because we're using gerunds here. It's all ings and all of these. It's always a noun, delaying the conduct, seeking influence.
I withdraw my objection to the gerunds.
So we'll go back to making and failing.
But I had a different point.
I'm
Okay.
sorry.
Okay. Anyone else had a comment on that before we move
Yeah.
on?
This is Randy May. I just think it would be just as well, or perhaps better, to end the sentence with knowingly making false statements, because I think knowingly failing to correct false statements ultimately is really subsumed within that. And if we went down this list, I think we would find other sections where we could extend it to cover all possible actions, if we use actions. But it just seems to me that knowingly failing to correct false statements would be understood commonly to be subsumed within knowingly making false statements. So I'd put a period after statements myself.
I would agree with that. Is there anyone else who wants to comment on J? Any other comments on J? Okay,
I
then
can,
we'll
I can
go.
live with that.
Okay, great. Then Erica, you said you had another comment?
Can we just look at I for a second? I want to, it may just be that I need to understand this one better. When we say delaying the conduct of an adjudication, I guess I have two questions. One is required by the client's legitimate interest the only situation in which a person might sort of acceptably delay, ask for delay? I mean, I don't know what delaying the conduct means. If we mean conduct intended to delay in some fashion in a bad way, even if it were in the client's interest, it wouldn't be okay. And if the idea is doing things that have the effect of slowing it, I guess I just need to understand this better, because it seems to me that if it is an abuse of the process, even if it's in the client's interest, we don't want it. And if it is not an abuse of the process, it's just a request for delays or extensions, then there are other acceptable reasons. So I guess I need to understand a little bit more what we're trying to get at.
What about if it said unreasonably delaying the conduct of an adjudication unless required, or just unreasonably delaying the conduct of an adjudication? I just think when we look at this list, and if we all thought about it, there are a lot of different sub extensions and sub A's, B's, C's we could come up with, but there has to be some judgment involved in applying these factors. There will be judgment applied.
I agree. Shorter is better. I just didn't understand why we would be condoning and accepting delay if delay is bad just because it was in the client's interest.
Can we just ask Professor Cohen if he has a comment on that? Because again, this was drawn from probably an ABA model rule.
Yeah. So the ABA rule says a lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the client. So that's the way the ABA rule is written. So that's why they put that in there, but they should have put in unreasonable. But I would just make a general comment. To me, the original intent of this list was just to list topics, not to list specific language, recommended language. I think that would come later. So I think some of the discussion about the language, I think, is more appropriate for if and when the ACUS decides to draft specific language for model rules.
So are you, does that mean we should leave? I'm a little uncomfortable with this notion that a client's, maybe it's the legitimate takes care of it.
Well, I think just unreasonably delaying the conduct of adjudication, period.
Period. Yeah, that addresses.
Yes.
Can I just speak briefly to the Ms. May's comment that the reason that I use more words rather than less is that simply the short phrase like conflict of interest, for example, by itself, this is all in the context. In the original discussion, we were asking, was this the last meeting, are these conduct that apply to a specific adjudication, or that just as in general, you don't want to allow somebody who does it to represent people at the agency, put aside any specific adjudication? And we're trying to figure out which those were. And it turned, as I read them anyway, in the context of Professor Cohen's paper, it was hard to create either or categories. But once you spell out a little bit more, drawing on his paper, you begin to see the differences. So a conflict of interest, I think what they're talking about is, as is described in subparagraph C, we should put a little flesh on it. It doesn't mean, for example, you're dealing with a representative whose spouse becomes the head of the agency, put aside adjudication, it focuses in on specific conflicts. That's the reason I tried to beef up the language a little bit by drawing on for the most part, the model rules from which those phrases had their roots. Now, of course, you might say, well, that just complicates things. And you just want to say, for example, instead of ex parte contact, instead of saying unauthorized, just say ex parte contact. But obviously that fails to recognize that some ex parte contacts with agency officials is legitimate. So obviously I think it's a little better to put some flesh on these things, but you may decide you want to just go back to the bare bones reference to a topic.
Thank you. Eloise, you had your hand raised?
I did, for a different letter on the list. Is it okay to move to a different letter now?
Yes, that's fine.
There we are. Okay. So I noticed that M, which is now off the screen, seems to be, it doesn't have any red in it yet. So I wonder if it is a holdover that didn't get incorporated into Russell's list. So that's sort of question one on M. Then I noticed substantively letter M about violating agency rules. There seems to be some overlap with letter E, knowingly disobeying valid agency rules. We've modified it a little bit now. So I wanted to know if they, maybe I'm wrong that M is not just a holdover and that is actually intended to reflect something different than E, in which case I'm not totally sure what it is. And then point 3 on M is just that the committee of style should make sure that everything is in parallel construction. So I believe this too needs to be moved not in the verb form, but into the noun form or the gerund form, as we were saying before. But the committee on style should just sort of smooth all these over. But substantively, really, I just don't, maybe somebody, and I don't know if it's Russell or Gavin or
it's just left over. It's left.
It's just left over. Okay. Okay. Well, then maybe we should.
I couldn't find a parallel for it in the. I think this is right in Professor Cohen's paper. It was just there.
It's another ABA rule. It's rule 8.4a.
Okay.
And it's meant to apply generally to all of the rules, not just the ones that are subject to whatever that the other rule was that you were talking about, the compliance with the agency rules. I mean, I guess you could say.
So is there a way? Go ahead. Sorry.
Yeah, so I mean, it's just that in the ABA formulation, those are separate rules, although obviously there's some overlap. There's a lot of overlap in the ABA rules in a lot of areas, but it was just meant to cover attempts generally, which would also address one of the issues we were talking about earlier about disrupting the conduct. So you could say attempting to is kind of covering that too. But that was just again, it's just kind of copying an ABA rule.
So just to make sure I understand, are you suggesting that there's some value in having it be separate, having M be separate from E, as opposed to trying to either smush them together or?
Well, I mean, so E is just compliance with agency rules generally, and then M is just directed at the conduct rules that even if you just attempt to violate the conduct rules, in the ABA ethics rules, that it's a separate attempt is a separate violation, and then assisting others in violating a conduct rules is a separate violation from you personally violating it.
So if there's some meaningful difference, I'm then comfortable with keeping them separate. As a stylistic matter, I think it might make sense for them to follow each other, just so that it's clear what the point of difference is, but maybe that's a committee of style thing. And then I also wonder if there's a way we can add a modifier maybe in E, because if we have the modifier conduct rules in M, I wonder if there's a way to add some kind of modifier, and I'm not quite sure what it would be, but to get at, I think, George, you were using the word general before, or overall, or I don't know if others have thoughts about this, but that would at least help for me to make it more, both the sort of having them be contiguous to each other and having some kind of modifier would at least help me differentiate between the two.
Okay, I see other hands raised. Does anyone want to speak on this specific topic? If anyone else has a comment on that topic, you can go ahead and speak.
I agree with Eloise's concern. I think the reader would be a little bit confused by this. So if we can't smush them together, as she suggests, then they ought to be followed with appropriate following each other with appropriate modifiers. I don't have the language in hand. I also think that in G should also probably be failing to provide, just to add the gerund there.
Okay, so going back to E, the concept there is knowingly disobeying agency rules more generally. Is that the idea? I'm not sure what we're.
Well, I think that's what George had been suggesting was the main difference between, sorry, I'll get my hand back up so I come to the front of the screen. Was the main difference between E and M was a general distinction. I guess the reason why I'm having trouble coming up with a good modifier for E is because now we have smushed together agency rules, which are general, but adjudicators' orders, which are specific to this individual case.
Right.
And yeah, and then there's yet a third level of generality, which is now in M, which is kind of conduct rules. And so it's just like.
And M also has the concept of assisting others, which is
exactly,
which is another, right. And the
so there's
idea
four different levels. Yeah.
The idea of agency roles generally might be too broad. So if this is an animal welfare proceeding and someone, I don't know that the agency wants to address violations of an entirely different type of proceeding. I don't know if we're trying to be strict to this proceeding. Go ahead.
My instinct would be following George's point that these are getting at different concepts, but also following George's point that we are just suggesting topics here and the agencies can further kind of flesh out all the details. My instinct honestly would be to mush these together, to mush E and M together, because each one mushes things of different levels of generality already. So the whole point here is that this is a general topic of efforts to disobey stuff. And here's some part of the efforts to disobey stuff that we've thought of. You may think of others. So that would be my instinct, knowingly disobeying.
How about if in E we said disobeying valid agency rules, including conduct rules?
Or yeah, conduct rules or adjudicators' orders can be considered.
Yeah, but
yeah,
but it could, including conduct rules or adjudicators' orders, and then you could have a comma at the end of adjudication orders, comma, or knowingly assisting others in violating.
In doing so.
Yeah.
I'm not sure though that you'd want to necessarily limit it to conduct rules in E, because what about just compliance with a rule of procedure? That's
So
not,
this is adding to agency rules. I thought this was adding to agency rules, including
oh, including, okay, yeah.
conduct rules or adjudicators' orders.
But then why do we need including conduct rules, I guess? So maybe maybe the idea, maybe we don't need the specific point that's the first half of M, because obviously it would be, conduct rules would be subsumed into agency rules, but maybe the valuable part of M is in the inducement of others. And then maybe that's the concept that should be brought up to E, but as like the more general principle that we don't want people to be inducing others to violate any of these, including compliance with orders. Like if somebody tells the client to sit down, you want the client not to be egged on by the just to not sit down.
I think it's useful to keep conduct rules in there because there's so many different types of agency rules.
I agree.
We're trying to highlight conduct rules in M. If we're going to save that, we ought to put it.
I
put it in
agree.
there.
I agree.
Gavin, could you put the or knowingly, if make sure we get this right, or knowingly assist others in doing so in E? I think we should try to drill down on the language here.
So we're going to get rid of M and just modify E.
Yeah, exactly. And Eloise, if I understood you correctly, you were saying have a comma after rules. Okay, yeah, good.
This still would not, the new E would still not go to attempt. We would still need some element of that to remain consistent with the original language. To George's
Well, it
point,
could
that
be
was-
knowingly disobeying or attempting to disobey.
Could we put a comma after rules under including conduct rules, comma?
Yes.
No, after including conduct rules. Yes,
Right
there. Now, could we use a different word than orders? I'm a little concerned that orders, you know, whether that's an order under the APA, what we mean is when the adjudicator says, sit down, stop talking, I've heard enough.
Instructions.
Directives.
Direct, I think directions would be better. Thank you.
Was there anything else on E before we move on?
Just as an aesthetic point, don't you really want to have a comma after rules as well? Agency rules, comma, including conduct rules, comma.
That would be my preference too.
And this is high. I'll just jump in for one thing on line 33. I'm not sure that, I know someone had put in valid at some point, which we didn't have before. Is there a reason to modify it for a valid agency rule?
I'm pretty sure that just drew from the parallel model rule.
Yeah, but it seems odd for us to seem to
Yeah,
indicate that we
I
think,
agree.
I would just take it out.
And then do you want to strike M? Isn't M gone now?
Yes. M should be stricken. And then can we, Gavin, maybe we can go back to A and just quickly run through in order. I'm afraid that we might miss something because we've been jumping around to different letters. I think we had gone over A. Were there any concerns with B? Any concerns with C?
Can I just make a committee of style point, which is that everything should just be reviewed for consistency, whether like these do not have ing at the top, but maybe it works, but I don't think we should spend time thinking right now about whether some can have no ing and some can. Just if everybody could make sure, the committee of style could just make sure, I think we can tuck that away.
But the gerunds aren't going to work for some of those. I mean, gerunds not going to work for A. And
I
mean,
know, that's what I mean. That's what I mean. There
Yeah.
will be some of these where gerunds won't work, but somebody has to just give 2 more seconds of thought to grammatically why and making sure we have the right form. And although I did used to teach 7th grade grammar and I could do it, I don't think it's a good, I mean, I know everybody could do it too. I don't think it's a good use of our committee time now. So I was just suggesting that the committee of style make sure that everything is consistent for proper form, whether it's in the gerund form or some other form.
Correct. Do we need to put a note? I think you are putting a note. Okay.
Reeve is obsessive about these things, so and I to a lesser extent. So it will be taken care of, note or no note.
Thank you.
Absolutely. Absolutely. One other quick thing on C. So we had bracketed the former client
Right.
for the committee's discussion. At least from my perspective, I think it's worth, seems worth including, but we wanted to make sure the committee was on board with that.
And anybody who teaches 7th grade grammar deserves a medal.
So the question is whether to include a former client, whether to remove the brackets or delete it altogether.
Exactly.
are those parallel? I mean, it seems to me representing a former client could not be might not be a conflict of interest in the same sense as having representing 2 clients before the same agency at the same time in the same kind of proceeding.
Yeah, I'm
As opposed to somebody you represented 10 years ago. I don't, they're not parallel anyway, are they?
I don't think it's a violation of professional responsibility to represent a new client with interests contrary to a former client.
Right.
That makes sense. So probably counsel in favor of just deleting it.
I would be in favor of deleting.
Especially you say including, that means these are examples. They're not
Good point.
They're not the universe.
Okay, so any other comments on A through D before we move on?
I actually had my hand up for something on D.
Okay, go ahead.
So it's minor, but I think we've economized the word so much there that it looks like defending against a frivolous claim would be problematic. And so I'm wondering if it would be better to split those into 2 and just say filing frivolous claims or asserting frivolous defenses, which I think is what we were trying to get at with adding the defending in there.
That works.
Good
Any
change.
concerns with that? Any other comments on A through D?
I'll just add about, I was the one who suggested the former client change. That is a provision of the ethics rules. You can't represent someone adverse to a former client in a substantially related matter. But I mean, it is just a representative list, so I don't feel that strongly about it, but that's why I suggested putting it back in there.
Any comments on E? I think we've.
Yeah, I'm still a little troubled by E. And it's maybe just, I'm being a punctuation nerd here, but we've got the comma after on line 33, including conduct rules, comma, or adjudicator's discretion, comma, or. We've got those 2 ors and they're not really parallel. So maybe including conduct rules in parentheses might help. And then you can take out including conduct rules. You can take out the comma or adjudicator's directions, and then the or makes more sense, or doesn't
Okay.
seem. Yeah, that's better for me.
Good change.
Or you could use semicolons. Strike the or.
As opposed to the parentheses, is that what you're suggesting?
Either way, semicolon where the cursor is now.
I don't think you can do that because we don't have a true list of 3 things that are parallel.
Right.
Okay.
I agree.
Okay. Oh, Randy, I see your hand is up. I'm sorry. You've been waiting for a little while. Oh, you're on mute. Oh, you're still on mute.
I apologize. It was left up. I'll get better at that.
Okay, no problem. I just wanted to make sure I didn't leave you out. So we can go to F. Are there any concerns with subparagraph F? I don't see any hands. Go on to G. Failing to provide competent representation. Or H, unauthorized withdrawal of client representation. Or I, unreasonably delaying the conduct of an adjudication. I think we discussed that one already. J, I'm wondering if J should be knowingly make a false statement. I'm reading it as you'd have to make more than one false statement. The way it's written. Maybe that's just me. Robert, I see your hand is raised.
Sure, thanks. And I apologize if I missed this earlier. I had to drop off for a moment, but on J, I think that why aren't we using more of the common law fraud standard, making a material intentional false statement? Because knowing seems like too high of a mens rea standard from as used in common law fraud. And of course, in order to be falsification, fraudulent falsification, a false statement also has to be material.
So can you repeat the language you're suggesting?
Making a material intentional false statement.
And so
knowingly would be deleted.
Any concerns with that change? Any other comments on J?
Capitalize
Is
the
that-
M in making and delete the S in statements.
That's a stricken. We'll make all these changes. It's just hard to see.
Eloise, you had your hand raised?
Yeah, I'm interested in Robert's suggestion, but I don't totally understand this now copying some standard. So knowingly is the work that knowingly is doing modified strikes me as slightly different than an intentional false statement. Like how can a statement be intentional? So it's sort of like you're modifying the doing of it, which is why knowingly makes more sense to me. But I'm also all in favor of ACUS not making up random words that sound good to us when there's some other legal standard out there that we should be hooking onto. So is the phrase that you've suggested an actual sort of term of legal art phrase? And if so, if those words are all right, is it done, if those words are part of the external standard, is it really in that construction, a material, intentional, false statement?
I think that question is for Robert.
Yeah, that's certainly the way I've seen it. That's the way my agency applies it in falsification and fraud in the federal job application process. There's similar formulations in federal immigration law and securities law under the False Claims Act that basically it's intentional rather than knowing, because it could also include recklessness. The materiality requirement, for example, under the Supreme Court's Escobar decision, has a subjective element. Was somebody actually influenced? And an objective element. Even if somebody wasn't actually influenced, would a reasonable fact finder have been influenced?
Great. So if that is tied to some external legal hook, as you're explaining, then I'm certainly in favor of it.
And it sounds like it's a slightly lower standard than knowingly.
That's right.
Any other comments on J? Okay, we can move on to K, improperly seeking.
Two.
Oh, sorry, there are comments.
You need to put two after seeking.
Improperly seeking to influence
Yeah.
the conduct of a judge or official.
And then you need that and at the end, because we deleted M.
At the end of L, delete and. I think that's what you were referring to. Any comments on L?
I have a comment on L.
Yeah.
So I think we're a little too specific here. I mean, I don't know, some agencies might be more bothered by a regular misdemeanor, not a serious misdemeanor. And we don't say anything about how serious the civil violation has to be. So I think we should just say, go back to conviction of a crime or conviction of a criminal act, maybe conviction of a crime, or official finding of a civil violation that reflects adversely, blah, blah, blah. And let the agency decide whether they care about how serious it is.
Conviction of a crime or official finding of, should it be a civil violation?
Yes, a civil violation.
That reflects adversely.
And then go all the way to on the attorney's fitness. Yeah.
Any comments on that change? Conviction of a crime or official finding of a civil violation that reflects adversely on the attorney's fitness to represent clients before the agency.
Yes.
Any other concerns with L or with any of the lettered subparagraphs? If not, I think this might be a good time to take a short break before we move on to 4, unless anyone wants to, unless everyone else wants to continue moving on. I'm at your mercy. Okay, why
Let's
don't
take
we
a break? Thank you.
Yeah, why don't we take a short break, maybe a 10-minute break, not quite that short, but so let's return at 11:50. If you want to start recording. Before we move on to 4, I do see that Erica Litzen had to drop off, so she placed a comment in the chat on a question she raised earlier that she voiced verbally. So she's written it in the chat if we want to talk about that. Her concern was she wanted to include the process for identifying and dismissing complaints that are frivolous, repetitive, meant to harass, or meant primarily to delay agency action, including any consequences for persons filing those complaints. She goes on to say that there might be that might be behavior that's inherently already covered, but she wanted to just have the committee consider whether this should be, she sees value in having that included or mentioned specifically. Does anyone have any concerns or suggestions about that? We don't have a separate lettered paragraph for that type that specifically addresses that. Is there anyone who feels that we need to or that we don't need to? Either way.
I'm a little confused. I thought that she was referring to what's now
D?
Paragraph 7. No, I thought she was referring to a different item, a different, totally different paragraph.
Okay.
So she's not talking about paragraph 3. I don't have it. I mean, I have what was circulated on Friday. So, but I think that was what was circulated on Friday. It was on paragraph 7 on page 3. So I think we're not there yet, is what the way I read her comment.
Okay, got it. So we'll get to that when we get to those 7. All right, my apologies. So we can move on to paragraph 4, unless anyone wants to revisit last comments on any of what we've done so far. If not, we can move on to paragraph 4. Okay, are there any comments, questions, concerns with paragraph 4? I don't see any hand raised for paragraph 4. Alice?
Yeah, I've had an issue with on line 52, and I don't know if I really care enough to suggest that it be stricken, but where it says other agencies with a similar mission. I mean, I'm with the State Department. It's like, what's a similar mission? I know probably not HUD, but I mean, Commerce, is it Treasury? Is it DOD? I mean, it's seems kind of vague to me. And with some agencies, it might be hard to nail that down. In other words, I don't know that it adds anything meaningful to this line, but happy to think about what others say.
Alice, just to be clear, you're proposing just striking the other agencies with a similar mission at 52, but not necessarily striking the language at 54 through 57. You'd still keep the idea of potentially harmonizing across agencies.
Oh yeah, I mean, if I'm practicing before TSA, if I'm doing an adjudication or something in TSA, and you know, I think TSA's rules should be the same or similar to FEMA's, you know, within DHS, but when you're comparing between like state and DHS or state and Commerce, I think that's hard to do, because how do you tell which agencies have a similar mission? But yeah, within one agency, I think all the components should have harmonized rules anyway. They're all going to go to their GC in any event. So anyway, that's all.
Got it. So you would just propose striking this similar mission language.
That's what I would propose. If somebody can articulate a good reason to keep it, I'll think about it. But as an agency attorney, I don't think it's helpful.
Yeah.
Any other comments on 4? I think we can move on then.
I
make
a
I'm
belated
sorry.
comment on 4. I'm just wondering if when it says agency an agency should consider whether to harmonize, should it be agencies? I'm not sure how a single agency harmonizes rules across multiple agencies. Maybe that's a quibble. I'm in the
No, I
last
had I
sentence.
had the same question.
You're on line 54 and
Yeah, the last sentence there.
I agree. I think it should be agencies should consider whether to harmonize.
Alice, did you have another comment or is your hand still up?
No, I think that's,
Okay.
no, I was thinking whether or not I like that, but I think I like that. So I'm going to put my hand down now.
Okay. Eloise, you had your hand up?
Yeah, I think when Reeve spoke, he just said agencies should, which I think is better than agencies may also consider.
I agree. For what it's worth.
Okay, if there's no further comments, we can move to paragraph 5. Agency action in response to a violation.
And I guess maybe one sort of question before that, Carrie, would be, is the committee on board with striking 5, 6, and 7 as the staff has proposed here, the qualifications?
Yes, if there are any concerns with striking 5, 6, and 7. Bill Funk?
Well, I apologize for not having been here at the last meeting, which I couldn't attend, but I'm not clear why all of 5, 6, and 7 should be eliminated. Certainly 5, it seems to me agencies should address whether only lawyers or other people can do this. I mean, presumably many agencies have already done this, but if we're addressing this to people the agencies that haven't considered this issue, I don't know why we wouldn't include 5. We could talk about 6 when we get to it, but I'm not sure why we shouldn't have 5. I'd like to hear from Reeve what the reason for 5's elimination was.
Sure. Yes, a fair point, Bill. I mean, and we can discuss the other ones as well. But our sort of point for eliminating all of them was sort of, we don't want to refer to qualifications specifically, but perhaps we can maybe capture the idea of 5 in number 1, that the agency should consider rules with respect to lawyers as well as non-lawyers. I think perhaps the lawyers, non-lawyers distinction is a useful one to retain. So if we could perhaps, work that concept into number 1, just whether, agencies are considering adopting rules generally, part of that would be, is it just lawyers or also non-lawyers? I tend to agree that's a worthwhile concept to retain, regardless of whether we retain the rest of what was previously at 5 through 7.
Reeve, would you anticipate that the draft preamble for the committee's consideration will say something to the effect that acknowledge that representatives can come in multiple forms, lawyers, non-lawyers being a key distinction, and that this recommendation is not going to take a position on when agencies should permit non-lawyer representatives to appear? Is that likely? Is that likely to be in the draft?
That is what I would anticipate. Yes, exactly.
And if I could say, I understand why 6 is sort of irrelevant as much as all it's saying is you can't do any more than the law says, although sometimes it might be worthwhile to point out to agencies who aren't necessarily well informed about 5 USC section 500 that this just, to say that. And then with respect to 7, again, I don't think we should tell them what the qualification should be, but I can imagine an agency saying, well, sure, let's have some non-lawyer representatives, and then not think about, well, should we have standards for them? And I think the idea that, they ought to think about whether they should have qualifications for them or whether anybody can just come in. So I just thought, we're not telling them what qualifications should be, but it just seemed to me it was a good checklist to say, well, you ought to consider qualifications as opposed to just generically letting anybody in.
And do you think, Bill, with that one as well, perhaps addressing it in the preamble would be sufficient, that we sort of lay out, there are lawyers and non-lawyers that could potentially be representatives, and the agencies, will consider, what, if anything, they want to provide for each of those two different classes?
Well, actually, I don't think the preamble, because it's really a recommendation of what they should consider, which is all of what all of our recommendations are, is recommendations of what they should consider. I mean, we shouldn't tell them what qualifications, but I think it's a good checklist to say you ought to consider having qualifications if you're going to have non-representatives. You can decide not to, but at least think about it. It wasn't clear to me why there was really the felt need to get any statement about qualifications out altogether.
Fair point. I mean, I think our thinking was, we can't really say anything specific here other than, identifying a statute applicable to lawyers. But if what you're proposing is at some point, whether here or earlier, simply say that the agency should consider whether the rules apply only to lawyers as well as also non-lawyers, and then as part of that, consider which things they're going to apply to lawyers as well as non-lawyers. Then I suppose, including potentially qualification, among other things. I think it's up to the committee, but I mean, I think that's probably a concept that could be relatively easily captured, either in some section or perhaps earlier in the document, just in number 1 or number 2, simply laying that out as something for agencies to consider as part of deciding whether to adopt rules and what those rules will contain.
I see Jeff Lubbers has his hand raised.
Yeah, I want to support Bill's point on this. I think it is worthwhile, especially since the Agency Practice Act is such a little known statute, to have something in the recommendation about this. And I think if we were to leave this section in, probably should have a version of paragraph 6 first, and then a combined version of 5 and 7 next. Now, if we don't want to have a separate section called qualification, you could have, you could add some paragraphs in adoption of rules, which is, which is only recommendation 1, but you could have a recommendation 2 and 3 under adoption of rules, and then move this part there. But again, I would first lead off by saying that, yeah, there's this Agency Practice Act, and it sort of governs what the agencies can do with respect to lawyer representatives, but it doesn't govern what agencies can do about non-lawyer representatives, and so agencies should think separately about that. So my suggestion is to leave in the content of this section, but move it into adoption of rules.
Any
I'd
other
be happy
comments?
with that. I'd be happy with that.
Okay. So do we want to move on to agency action in response to violation of rules, or go back to adoption of rules?
Yeah, I think that's, the key question, I guess, Carrie, for the committee. Like, is the committee on board with, what Jeff and Bill are suggesting, in which case, we can, prior to the next meeting, draft up something as part of the adoption of rules section that would capture these concepts. Keep in mind, some of this will also be going in the preamble, like, the Agency Practice Act will certainly identify in the preamble. So we can take a shot at sort of, capturing this concept, and then the committee can react to that next time if they're on board with it. If others, I forget if Bill and Jeff are on the committee, but if other committee members are on board with that, then that's what we can do as on the ACA staff level.
Are there any other committee members? Are there committee members who want to comment on that?
I think Eloise might have a comment.
So that sounds, is that okay, Carrie?
Yeah, please.
Okay, thanks. That sounds fine to me, that proposal. I just want to make sure that we're talking about keeping the qualification rules as a separate list from the conduct rules. We're not talking about merging them back, right? Because I think one real advantage of the way this is separated out now is that it avoids the intermingling that the first draft had. So yes, we're talking about that, because if we are, then I'm thoroughly on board.
So I thought the suggestion was to combine them, but maybe I misunderstood.
I guess what I understood was that we would move all of it up to the, Gavin, you want to go up so people can see it, the very first section on adoption of rules, that it would appear there. It would be one, and then we would add some additional material relating to essentially as part of laying out the rules. They need to consider lawyers and non-lawyers, and then they also should consider qualification standards for each.
You know, I take Eloise's point, though, that number one includes, well, the first paragraph talks about conduct. And then that's fleshed out by the next section, which is rules of conduct. So maybe I take back the suggestion of moving it into number one and just leaving it as a separate section, the way you drafted it previously, as qualification rules or something like that. That might be a better approach to keeping it separate, rather than trying to jam it into number one, since number one only speaks about conduct. So I take back that suggestion, but I continue with my suggestion of starting with 6 and then a combination of 5 and 7.
Eloise, did you want to follow
Can I just,
up?
I was just, yeah, just quick follow-up is that I just think qualification is different enough than the conduct that they just shouldn't be smushed together.
Yeah.
And then I guess
I'm
sequentially,
agreeing.
okay, great. And then sequentially, personally, I think qualification comes before conduct, because like you have to first get in the door to be practicing before the agency before you can do anything bad. So if we're talking about reordering all of this, it even more makes sense to me to move the qualification rules up. But I would just think about it in a parallel way. So if there's rules of conduct, I think that should be preceded by rules of qualification or something like that. But I just like I think they should be distinct. I'm making 2 points. They should be distinct, and that I think sequentially rules of qualification comes first. There may be some better term of art. This is so far outside my, area that I don't know what the term of art is, other than rules of qualification.
If we do that, and I think it's a good idea, I think we need to put back into number one, participation and, or, which we've taken out now, because that would make it more sensible to put the qualification section after number one.
So just to make sure we reflected this clearly, so the changes would be we keep adoption of rules governing participation and conduct. Following that, we had a new section on qualification per Eloise's suggestions to move that up. That will include some modified language based on what's currently in 5, 6, and 7. And then following that, we would have the rules of conduct section. Does that correctly capture?
Except that I don't think what's going on the screen now is right. I think we would leave one as one, and then we put back in governing participation and conduct, and in the title and the text. And so put back in participation and on line 7. And
there'd be a new 2.
There'd be a new 2. Which
Well,
would,
is it 2 or is it?
oh,
is it
no,
separate?
no, wouldn't be a new 2. It would be just rules pertaining to qualification. And then we'd move 6, we'd have 2 paragraphs under that.
Great. So just to make
A
sure
new
we
heading.
can.
New
Exactly.
heading.
New heading, Gavin, rules of qualification. We can wordsmith it later, but just add
Yeah.
the new heading in.
Right.
So it's clear to everybody. And then we will have 2 new paragraphs under that drawn from
Right.
current 5, 6, and 7.
Right.
And Kai had her hand up.
Yeah, I just wanted to speak to the foundational question here. Again, just thinking about ABA issues, etc. One of the things that I thought was noted in those initial comments in this new approach that is getting rid of 5, 6, 7 is that we weren't going to delve into the attorneys, non-attorneys issue. We weren't going to be delving into the qualifications. I understand that what we're doing is simply saying there are these other rules that apply, but I'm not exactly sure we're adding much to the conversation if we say that. So I just wanted to put it out there because I thought it was very helpful based on the concerns generally that were raised in the first meeting that we had now narrowed this to some of the conduct issues. So I'm not sure if I missed something that we had decided we did want to do this. I'm sorry, something had come up, but I really liked not dealing with it.
The qualification rules.
Yeah, I mean, if you just go down to, can you just scroll down, Gavin, again to what we had and then, yeah, and then what the recommendation was, right? Am I right that the recommendation was simply to delete that whole section?
Yes, but you missed Bill Funk's original comment on this, in which he
Okay.
suggested putting it back in.
And why?
And I supported it because with respect to qualification of attorneys, the Agency Practice Act dictates that, agencies can't require additional qualifications, but this is a fairly little known statute, and it's useful to say, how agencies are sort of limited on that. But with respect to non-lawyer representatives, they're not limited. And they should not only consider whether non-lawyers should participate, but they should also consider specific qualification requirements if they do allow non-lawyer representatives. So we thought it was worthwhile putting it into the recommendation itself. And I don't think it runs against the ABA's point of view, which is that agencies can't add additional procedures for attorneys. I don't think the ABA cares so much about what agencies do with respect to non-lawyer representatives. I may be wrong
Okay.
about that.
So my comment on that is I'm fine with that, okay, because we're basically not saying anything more than what the Agency Procedure Act says. We're just reminding agencies that those exist and they shouldn't extrapolate from our comments about conduct, that they can also do something about qualifications beyond Agency Practice Act for lawyers, but that's different from non-lawyers. And if that's the rationale, then I would not put qualification up front because those are about non-lawyers based on what you just said. And the whole point that we definitely want them to adopt rules if they haven't, is about attorneys and conduct. So I'm sorry again if I missed something, but I just didn't want to not have something that put us back from what I thought what was positive in this new draft.
And Eloise, you wanted.
Yeah, I was the one who suggested moving it up, and I think that Chai's comments makes a ton of sense because of the distinction between the attorney and the non-attorney representatives and the main thrust of our rule. So I will withdraw my suggestion to move it earlier.
And I'm fine with that.
aren't we equally concerned about conduct of non-lawyers?
Yes, this is high. Yes, we are, which is why we are actually having that section, I think, because we're saying everything we've just said about lawyers, that's going to apply. And then let's make sure it does say that. And I think it does, doesn't it? Where does it say basically everything we've said above, it's going to also apply to non-lawyers? Yeah, I mean, we do need to say that if we haven't said it above. Yeah. Either by federal should consider adopting rules governing. Yeah, I think we do have it based on what Gavin just highlighted.
So then we've come full circle, I think, back to keeping language at under a paragraph titled qualification. Is that right?
Some modifications, yes.
With some modification to those. And Jeff, I think you recommended not having them ordered the way they are now.
Yes, I recommended moving what's in 6 first. Maybe I haven't decided whether everything in 6 is necessary, but moving 6 first and then combining 5 and 7.
And that's language, Reeve, that I think we'll have ready for the next meeting.
Sorry, yes, that's exactly right, Kara. I guess the only question I would have for Jeff is what exactly, I mean, it seems to me what's currently in 6 is sort of more preambular in nature. I mean, would we lay out the Agency Practice Act in the actual recommendation itself or in the preamble? Because it doesn't seem like we'd otherwise be recommending anything. We would just sort of be saying what the law is. And then I would assume the combination of 6 and 7 or 5 and 7, as you're phrasing it, would be something like, you know, they decide whether it's just lawyers or also non-lawyers. And then if it's also non-lawyers, then they should have, you know, set out what the qualification standards are. So I think I get everything what you're saying, except sort of, I'm not really sure what we're preserving for 6, other than just sort of preambular language stating what the law is, what the agency.
Well, it's preambular language, but it also draws a distinction between agencies, you know, powers over lawyers as opposed to non-lawyers. And if there's a way that that can be put in here, I think it would be helpful. Otherwise it's only in the preamble. And I think sometimes people don't read the preamble. So I don't know, maybe Bill can help me out on this, because he was the one who originally suggested the value of keeping 6 in, and I agree with him, but
I mean, I still think it's worthwhile, but I don't want to fall on a sword about it. But if we kept 5 and 7 as a combined thing, then we could change the title of qualification to, you know, qualification for non-lawyer representatives, making it a much, you know, more specific general title there. And I could live with that. I mean, assuming that the Agency Practice Act will be discussed in the preamble. I prefer it in the recommendation, but I could live with it in the preamble.
I mean, you could just say something like, although agencies are, with respect, well, although the Agency Practice Act limits agencies' ability to establish qualifications for lawyers, agencies should consider establishing qualifications for non-lawyers, something like that. But, you know.
Yeah.
That makes sense. That makes sense.
That'd be much shorter than what's there now. Okay.
And therefore, just to make, so the section would be called qualification for non-lawyers or non-attorneys or whatever language we're using. And then it would have one recommendation that would note that the Agency Practice Act limits the ability to set qualification standards for lawyers, but the agency should consider qualification standards for non-lawyers. Does that
Something like
capture
that.
it? Okay.
Yes.
And actually, maybe it shouldn't go here, but maybe it should go at the very end. I mean, qualifications for non-lawyers doesn't seem to really fit between
Right, I agree.
conduct and agency action response to a violation. So it's just an additional idea.
That makes sense, Bill. Although, are you moving to the very end of the recommendation or after the violation of rules section?
Before transparency.
Before, okay. I think that makes sense.
Yeah.
Can I raise one question?
Sure.
This is going back off on something I said a little while ago. I just want to make sure that the list, the paragraph before where we list the conduct rules really does say applicable to non-attorneys. We scrolled past this very quickly and we didn't actually land on this when we were reviewing it. Yeah, this is the paragraph no, it's right before this. It's now lines 16 to 20, around there. I can't see the screen, but Chai, does that cover what you were asking about? Because I want to just, before we move on, make sure it does.
It was paragraph 1 that covered it.
Yeah, they had showed me paragraph 1, but
I know, but this is different.
Yeah.
Yeah.
Which,
so number 1 is very general about adoption of rules, but number 2 is about applying the conduct rules to non-attorneys. And I just wasn't sure whether we had landed on are we recommending that they adopt them wholesale for both attorneys and non-attorneys? And it looks like we are not. There might be some modifications. Okay.
Yes.
Great. And I just wanted to make sure because Chai had raised the concern about qualifications and were we telling them sternly that they really needed to comply, and we sort of are maybe, but with this consider whether to. So I just wanted to make sure that was responsive. Okay.
And I was just responding to, I think, Jeff's comment of making sure that we had it, and I was supporting that, but I think this does it.
Okay, very good. Okay, so scrolling down, I think we can move on then to agency action in response to a violation of rules.
And I can sort of briefly clarify, Carrie, on that one. So sort of what's currently 5, I don't know if that's still going to be 5, but in any event, we basically just lay out the agency should address what actions they would take in the case of violation. And then we just left it open-ended in the recommendation itself. But if you look at the comment to the side, there's an enumerated list or a bulleted list of items under possible action. And these are the sorts of things that we think the committee might want to consider. So anything from sort of a warning or a reprimand, all the way up to general disqualification, not only in a particular proceeding, but disqualification from practicing before the agency for some specified period of time, or monetary sanctions. And I guess the question for the committee is how much of that, if any, do we want to actually list as possible sanctions or disciplinary actions?
But Reeve, in some cases, the agency may not have the statutory authority to do one of these.
So that's where the memo that was circulated by Jeremy Grayboys, I might turn to Jeremy briefly, but I think our general position was, I mean, there are general authorizations as well as agency specific authorizations that seems like as a general matter, at least in the particular proceeding, the agency should typically have the authority to disqualify the person if the conduct is disruptive or so forth. When it comes to things like monetary sanctions and so forth, I think that that's right. I think that there may need to be additional statutory authorization, which may counsel in favor of not addressing that. But Jeremy, do you want to jump in? You know the statute.
Before you do that, one person who's not here I don't know who has a strong opinion on the subject is Allison Ho, our co-committee chair. With respect to this and other matters of statutory authorization, I suspect she's going to want, and the committee may well want, some reference in the preamble to the question of authority. We're obviously not going to resolve it on an agency by agency basis.
Yeah, I was just suggesting that the lead-in or the language of number 5 now implies kind of that an agency should, address all of these possibilities, and they don't necessarily have the authority to take all of those actions. So, with agencies should address what actions an agency may take, assuming they have the statutory authority to do so somewhere, because, I know that the INS or the immigration judges have special authority to have monetary sanctions, but based on the staff report, but I don't think other agencies feel like they have that authority. So yeah, that's the kind of thing I was looking for.
To follow up on that, I'm in favor of not being very specific. So for example, for SSA, we of course have the ability to sanction in an adversarial proceeding, as I mentioned on the last call, representatives, both attorney and non-attorneys, for various reasons. But some of the other aspects, either we don't have the authority for, such as disqualification for a particular matter, or monetary sanctions, etc. But in addition, there are certain elements that you don't have to explain in the rule. So if you have the ability to sanction, if you have the ability to disqualify a representative, then usually things short of that are implicit, such as a reminder letter or a warning letter. So for example, in our agency, when we give a reminder letter, or when OGC does a warning letter, we basically say, we have the rules of conduct, please ensure you follow it. Failure to follow it may result in a sanction by the agency, including disqualification. So I don't know, considering the wide variety of availabilities to the various agencies, including contempt powers, which we don't have, as long as it's very clear that what the rules are and the regulations that require what the rules are, usually at the very least, as you said a moment ago, including disqualification, I don't think there's a need to specify all of these areas. The agency knows what it has the authority to do and can only follow whatever its statutory or regulatory authority is. And I think putting in particular examples might just confuse it rather than make it clear.
And those could be put in the preamble as a list of things that we've found that agencies have.
I think we've all cut Jeremy off. I'm sorry. I think I started it.
No, that's fine. I think actually, Jeff, you captured it pretty well. I think cabining it with assuming they have the authority. I'm not sure I'd limit it to statutory authority, because courts have sometimes found the ability to regulate inherent in agencies' general rulemaking authority or their general authority to protect the integrity of their processes. But something along the lines of what you have there, Gavin, assuming they have the authority to do so, probably takes care of the situation.
And I see Allison has her hand up.
Yes, I just wanted to suggest a friendly amendment. This may be more in the nature of style, but instead of assuming they have the authority to do so, consistent with the authority or their authority to do so.
Okay.
Thank you.
Yeah, that can be massaged if needed later. And so the preamble would provide the examples, I think, is what you were saying. Okay, yeah, I like that. It would be good to have examples for the agencies, but it doesn't need to be in the rules. Any other comments on what's numbered 5 at the moment? Okay, moving on to 6. The rules applicable to attorneys. Agency rules should identify any reciprocal disciplinary procedures or referral procedures. Any comments on 6? Okay, moving on to.
Wait a second, hold on a second.
Yep, yep.
I'm not sure it's immediately clear what reciprocal disciplinary procedures means. I mean, it's kind of a term of art that we lawyers use, but we might need to explain it a little bit.
I agree, Jeff. I think the goal would be to do that in the preamble, or are you suggesting maybe like a brief, like separated by commas sort of definition here?
We just, can we say what we mean?
I think it would take more words than be appropriate here in this recommendation. I think explaining it in a couple of sentences, at least in the preamble, would be worthwhile, and I think that would do the trick.
Okay.
The explanation of reciprocal, right? That's your concern, what a reciprocal disciplinary procedure is?
Well, I assume it means that they would refer something to a state bar or something like that, but.
Well, I think that's referral. I mean,
What is reciprocal then?
Then I think it's taking an action based on what another entity has done, be it a state bar authority or another agency. Did I get that right, George?
Yes, that's right.
Yeah, and I think you should explain both referral and reciprocal in the preamble. I mean, they both are not apparent to a lot of people.
Agreed.
Very good. Okay, moving on to 7. The rules should clearly indicate how the disciplinary process works, among other topics they should address. A, who can make a complaint and how they can make it. B, how notice of a complaint should be provided to the representative who is the subject of the complaint. And I think this is, Eloise, correct me, I think this is where Erica
Exactly
wanted to discuss. Okay. And did
so
you
my
have
hand
a-
is up. No, my hand is up just to ask Gavin to cut and paste it and move it onto the screen so we can consider it holistically.
Give me 1 second.
From the comment that she inserted.
Is that big enough?
Yes, I think so.
Kevin, could you maybe, I think sort of the thing after the first dash is what she's proposing putting in, as I understand it. Could you actually add that as an item in the red line for discussion?
As an H? Add a
yes,
letter
exactly.
H maybe.
Such complaints, Dan.
Any comments on H now that it's on the screen? Any comments for any of the preceding lettered?
You have to move the and now.
Oh, yes.
I would raise for consideration possibly making this language consistent with the, is there a frivolous complaints portion in the standards of conduct topics?
D,
D.
line 32, yeah.
I don't know if the committee would like to make that language consistent across those two, or or if that's not a priority. Perhaps not.
Are you talking about picking out the words repetitive, meant to harass, and moving those into the earlier section as well?
I think it's just the concept of complaints that have to be moved, has to be moved. Because the previous section was more about frivolous actions during the case.
Well, so in filing frivolous, repetitive, blah, blah, blah claims. I thought this was Gavin was getting that.
It's having them match.
Modify claims by more than just the word frivolous.
Well, that's a different type of, that's filing the original claim that's frivolous. Now we're talking about frivolous complaints against attorneys.
Mm-hmm.
I guess the point is that if we're going to ask agencies or recommend that agencies lay out a procedure for this particular type of misconduct, it likely should be included as a topic of misconduct in the prior paragraph. Particularly if it's different, if it's a different type.
I think it's a different type, but it may be worth putting in there, putting in the earlier section.
How is it a different type?
It's a complaint against an attorney filed by somebody else.
Oh, I see.
It's not a frivolous claim brought by, it's a frivolous substantive claim brought by the
All
attorney.
right, I see.
It's a point I merely make for internal consistency.
So the heading for this section is agency action in response to a violation of the rules. Is that where we are? Yeah. And so if this is, the rules should clearly indicate how the discipline. Yeah, if we're talking about the disciplinary process for a violation of the rules, it does seem that that violation should be addressed in the violations section, in the rules section.
Yeah.
I see hands from Eloise and George.
Sorry,
So
Eloise?
this is a question, like a substantive question, and I just know the answer to it, and then I have a minor point. The substantive question is, can the tribunal itself, sua sponte, engage in a disciplinary process? And if so, do we need that separate? And I just don't know very much about this. So that's a genuine question. If the tribunal can, then I think we should put it here. So I see the highlighted language, and so maybe the concept doesn't even really make sense. So I just leave that out there as the question. And then I have a slightly more minor point in G, which I would just say, I think G involves two things. It involves communicating the decision to other relevant authorities and enforcing the decision within the agency. And I just think we ought to flip them so that you're going from narrow within the agency to broad outside the agency. So.
And George, you had your hand up?
Yeah, I just wanted to point out that in the ABA model rules, there the provision on frivolous claims does include frivolous assertion or controversion of an issue. So for lawyers, that would include, I think, filing a false or frivolous assertion of misconduct against someone else. So if you put that in there in 3, then you could, if you wanted to, limit 7 to non-representative people who make frivolous claims.
Okay. Did everyone understand that? Do we need further explanation?
I didn't understand it.
Could you explain that again, George? Sorry.
Yeah, so right now in 3, there is a provision on frivolous claims. And what I was saying is that the ABA ethics rules do not limit, in their provision, which is what this is based on, they don't limit it to filing frivolous claims. They also include asserting or controverting an issue in a proceeding in a frivolous way, right? Without any basis in law or fact for doing so. So if we included that in 3, that would cover, in my view, representatives who make frivolous assertions of misconduct against another representative. And so then if that's dealt with in 3 with respect to representatives, then all you would need to add in 7 is that it's also improper for a complainant who's not a representative or is representing themselves or something, if they make a frivolous assertion of misconduct by a representative, that's what would be covered in 7. That's what I thought Erica's was trying to get at.
Okay. Bill, you had a comment?
Well, taking George's comments, as I understand it, it seems to me that H still could stay the way it was. There may be overlap, but again, it's here really focusing on a particular problem with respect to disciplinary complaints. And I think the idea of specifying these in particular, the rules should identify particular issues with respect to frivolous complaints is sufficiently different that it's worth saying again if it's an overlap with 3.
So the repetition would be worthwhile.
Yes, and I would say the specification here is worthwhile.
Okay.
Specification that's dealing with frivolous complaints. That's just as opposed to just frivolous arguments, frivolous claims generally, which is what 3 really is aimed at.
So as to this language, which the Committee on Style can draft, would there be, would the committee support an addition of language as George Cohen described it up in paragraph 3?
I don't think you need it, but
Any concerns with leaving D as is then? I don't
I
see
hear
any
none.
hands. Okay. And so H would Process. Any need to modify H? There are no, I don't see any hand raised. We can move on to transparency.
Do you want to say complaints against the representative?
That would make it clearer. Complaints against representative.
Except we never use that above.
Oh, we have-
Everywhere, we're talking about the complaint.
So
The way it reads, it would be an open question about what who the complaint is directed at. I read it, I took it to mean a complaint by a representative against an agency official or adjudicator. Hi.
I didn't have that concern, but can you scroll up so we can see what the opening is? Because I think, I mean, we have complaint all the way through. By the way, I love this edition of something about frivolous. Just the rules should clearly indicate how the disciplinary process works. Among other topics, they should address who can make a complaint, the notice. See, I think this is clearly referring to the complaints about conduct, everything we said above. I think I'm not sure that I see the need to clarify who the complaint is against in H, since we don't have that in, you know, all the other sections that reference a complaint. I think agencies will totally get this point. It's really complaints against anyone, against other representatives, against, well, it's really, we just are talking about what both representatives or claimants are doing. But actually having frivolous complaints against the same AJ, that's, I don't know if we have it before, but that's annoying and should be dealt with.
Yes, and that would be covered under 3, not under 7.
Right, but what this is, the reason I like it is it's saying to the agency, and again, I will get to it, but I really think it will help agencies if there's a direction to the office of the chair to do like some model rules. It'll make it clear that in their disciplinary process, they can also take a look at whether this is now the third complaint, you know, the third time that they have, you know, maybe just sanctioned as opposed to anything broader. And this is in their process, they should have in the overall process, they should have a process for identifying and maybe dismissing complaints that are frivolous in a way that is more expedited than some of the other things above. I think they're going to want that.
We're going to have to wrap up. There is another meeting at 1 o'clock, so we're going to have to probably leave it here. Does anyone else have a burning desire to speak to this issue before we close out?
The only thing I'd like to say, and it really goes to the next one, and again, I wasn't scheduled to be here today, and I may not be at the next call. The transparency, the next part, why don't we just take out all significant and just say agencies should publish rules? Why do we need to modify it?
Carrie, I'm sorry that we did not handle the scheduling very well on our end. We're really up against a hard deadline now to transition to a forum that will have several hundred people on the line. So could I just ask you to recess us or adjourn us till the next meeting? And with my apologies for our inattention to the schedule.
Sure. And the next meeting is, let's see, Tuesday, November 16th, same time, 10 to 1. So we're going to adjourn. Feel free to send comments, written comments before the next meeting. Thank you, everyone. Appreciate your attendance.
Thank you.
Thanks. Bye.